Hi, I'm Andrew Meinzer of Meinzer Law Firm. This video is the 5th in a series regarding estate planning. So far, we've covered the goals of estate planning and how things can go wrong if you haven't done it. And we've covered how wills and trusts help with the first estate planning goal of transferring your assets the way you want and efficiently after your death. Although the trust does a much better job of being efficient and saving your loved ones lots of time and money. Now in this video, I'm going to discuss with you how to accomplish the second estate planning goal. And as I mentioned, that's arguably the more important goal, which is making sure that someone you know and trust will have the legal authority to take care of you if you cannot take care of yourself anymore in the future for some reason. If you can't take care of yourself anymore, then you're said to be incapacitated. You may be incapacitated if, for example, you were in a car accident and now you're in a coma. You suffered a stroke. You have dementia. It's important to plan for these things. As you can see, you can become incapacitated at any age. If you don't plan for these things, then if you become incapacitated, a conservatorship court proceeding may be necessary to provide someone with the authority to be able to manage your affairs for you. And a conservatorship court proceeding is a lot of work, it's time consuming, and it's expensive. And the person that ends up being put in charge of you through a conservatorship may not even be the person that you want. So there are 4 basic documents that can avoid that situation with a conservatorship if you can't take care of yourself anymore. Those 4 documents are a trust, a power of attorney for financial management, power of attorney for healthcare, and a disclosure authorization. We already talked about the trust in the last 2 videos. We're talking about it again because it does double duty. It helps to accomplish both of the estate planning goals. As I mentioned in the third video, the trust ordinarily will name you followed by others as a succession of trustees to be in charge of managing your assets. The next trustee in line after you will take over if you become unable to manage your assets anymore in the future for some reason. Then he or she will manage your assets for your sole benefit until your death because you are the initial beneficiary of a trust for your lifetime. Now, and it's common for a trust to be for the benefit of 2 people in cases like married couples. And you've selected in advance this person, so you know that it's someone that you trust. Now, just as you need a pour-over will that we've discussed in a prior video along with your trust at death, so too, you need a power of attorney for financial management along with your trust during your lifetime. The power of attorney for financial management names somebody that you know and trust to manage all of your finances and assets, and that person probably should be the same person as the trustee of your trust. Now, the power of attorney for financial management covers your finances and assets that are not assets of the trust. As we discussed in a prior video, you have to put assets into your trust for your trust to control them. So between the trust and this power of attorney for financial management, this person that you know and trust will have the power to control all of your assets for your benefit during your lifetime. Now, so far, we've discussed only finances and assets. There's another critical component to your life, which is your personal care, including your well-being and your medical decisions. You need a power of attorney for healthcare to name somebody that you know and trust to make your personal care decisions for you too if you can't take care of yourself anymore in the future. Then this person will be able to manage all of your personal care decisions for you, including where you live, who you spend your time with, and what medical treatments that you receive. The power of attorney for healthcare document should include a lot of specific directions that specify different types of medical treatments that you want in different kinds of situations, because that way the person that you named will have a roadmap to use to carry out your wishes. At that point, when a person needs to act on your behalf, you're not able to communicate with them anymore in a meaningful way. So that's why that roadmap comes in really handy. Now finally, you should have a document called a disclosure authorization. It doesn't give anybody any power to help you. What it does is it authorizes your medical care providers to communicate your confidential medical information to the people that you named in these various documents. That way, the people that you named will have the information that they need to make your decisions for you, in particular your medical decisions that might have to be made in a hospital. Now, you have a couple documents that deal with assets and finances and a document that deals with healthcare. You might put a set of people in charge over here for assets and finances, and a different set of people in charge over here for healthcare, and that's completely fine. They're different skill sets, and so that makes perfect sense. As long as everybody gets along well, that should not be a problem. And don't be too concerned about the titles of the various documents that I've mentioned. A power of attorney for financial management, sometimes it's called a power of attorney for asset management, or just a power of attorney. And a power of attorney for healthcare, sometimes is called an advanced healthcare directive. All right, so we have only one more video left in this estate planning series. Through it, I will discuss who needs to have estate plan documents in place. Go check out that last video, and I'll see you there.